For today's case, we discuss an incident involving an officer who tased and shot at, ultimately killing a mentally disabled individual, and discuss whether or not it was proper use of force. Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn your subscription. For today's case, we're discussing the case of Salvatore Palma versus Matthew Jones. In this case, we are discussing an incident involving Vincent Palma, who was a mentally impaired person. And the police officer showed up and tased and shot him under questionable at best circumstances. The Court of Appeals is reviewing a motion to dismiss, which was granted, and reviewing it under relevant law. And the question is whether or not there's enough to ultimately go to trial. So let's get started with this. First, let's begin with this tale of what happened, at least according to Deputy Johns. So here's what happened according to the deputy. On February the 8th of 2017, a cold winter day in Geneva, Ohio, Jones responded to a 911 call in the Palma's home. The dispatcher told John of an unwanted person, Vincent Palma, at the house. Johns knew Palma to have been unhappy with a TV show that was on TV, and he had broken the television remote. So yeah, this person is unwanted at the home apparently, and has been upset about what's on TV and broken the television's remote. Okay. Johns pulled up to the house and parked his patrol car in Palma's driveway about 40 to 50 feet away from the house. Johns saw Palma standing outside on the porch with a hood up over his head and his hands in his pocket, which immediately concerned John. So he arrives at the home. There's this guy outside. It's Palma, the guy who's going to ultimately be shot. He has a hoodie on and he has his hands in his pocket, which, the police officer finds concerning. Let's press on. Johns repeatedly told Palma to stop walking and take his hands out of the pocket, but Palma did not respond and continued approaching John. When Palma got within 20 to 25 feet of Johns started backing up towards the passenger side of his patrol car. Palma's parents, who had come outside, told Palma to just stop and do what Johns says to do. After retreating backwards to the side of his patrol car, Johns pulled out his taser. Johns warned Palma he would use the taser if he didn't stop approaching. Palma did not stop, and Johns tased him. The taser had little impact, and Palma began walking towards Johns, so Johns tased him again. This time, Palma fell to the ground and landed in a puddle on the driver's side of the patrol car near the front bumper. Palma fell onto his side, with his back facing Johns. Johns told Palma to roll over and show his hands. They were 6 to 10 feet apart at this point. Johns took a few steps towards Palma, but stopped when Palma did not respond to commands. Johns called for backup, asking them to step up their response. As Palma got up from the ground, Johns used his taser a third time. This time, Johns saw Palma use one hand to pull one of the taser probes out. Johns did not see a weapon or any other object in Palma's visible hand, and did not know where Palma's other hand was. After Palma pulled out one of the probes, Johns holstered his taser. Palma got up and started walking towards Johns, and Johns continued retreating backwards across the driveway. Palma was still not responding to commands. Johns then pulled out his baton. He raised it out over his head and prepared to strike Palma with it. But Johns did not use it because Palma momentarily turned away from Johns and looked backward towards his parents. A moment later, Palma turned back around and started walking towards Johns again. Johns said that Palma had a crazed look on his face, and that Palma's appearance, demeanor, and behavior told him that Palma was not going to stop. Johns continued to tell Palma to stop, and warned him that this is how people get shot. Palma was about 6 to 7 feet away at this point. Johns then unholstered his gun and pointed it at Palma while he was still retreating. This is while Johns is still retreating. Again, according to Johns, we're reading his description of the event. So Johns is saying that he is pointing his gun towards him while he himself is still retreating. Okay? Palma, however, did not stop. After Palma took 10 steps more, Johns shot him. Johns fired first at his leg in an attempt not to kill him, but to stop him. After the first shot, Palma continued to walk towards Johns, so Johns fired again, this time aiming for Palma's center mass. Johns continued shooting until, after several shots, Palma leaned over at the waist and got down on the ground to a bear crawl stance. While Palma was in this stance, Palma lunged at Johns. So Johns continued shooting, lunged at him while in a bear crawl, apparently. Johns shot at Palma until the moment that Palma no longer came towards him. Throughout the encounter, and again, we're still going through John's recollection of the event, so this is all according to the officer. Throughout the entire event, Palma never said anything to Johns, never reached out towards John, never verbally threatened John. Palma did not raise his fist or make any threatening gestures, but because Palma did not respond to commands and kept walking towards Johns, Johns believed the situation was more than a friendly encounter. Backup arrived shortly after the shooting. Johns then approached Palma and searched him. Palma was unarmed. Okay. So from the series of events we have described, we can see a couple problems. The most notable problem to me, that pops out most obviously to me, is that, as I think we all know, and I hope we all should know, the use of deadly force is authorized in response to deadly force. Deadly force is an imminent threat of death or grievous bodily harm. Now, Johns, according to his own testimony, started shooting him in the leg deliberately in order to just merely wound him, apparently, which, is a bit of a problem because, if your life is truly in threat, your ability to aim, the ability to aim at the leg is going to be compromised. And why would you? Right? You're going to aim at center mass. So the first thing that pops into my mind in running this analysis, or the most obvious problem to my mind, is the fact that his first shots were deliberately not targeted as torso, which goes a long way to suggesting that he did not perceive an imminent threat of death or grievous bodily harm. So not only was there perhaps not one objectively, the officer's own actions subjectively suggest against it. So that's the most obvious problem. Let's read some other statements about the event. Salvatore Palma, the father, recounted many of the same facts. However, he remembered taser application differently. As Palma approached Johns was yelling, "Stop walking, I'll tase you." Palma did not stop, and Johns chased him from across the hood of the car to the other side. Salvatore reported seeing Palma convulsing on the ground for minutes after Johns chased him twice, which one would think, if that's true, would give you the ability to restrain him at that point if he was really down that long. Eventually, Salvatore saw Palma get up and pull the taser wires out. Palma then looked back at his father as John pulled out his firearm and warned Palma he would shoot. Palma then turned back around and continued walking towards Johns. Johns continued to retreat, and Johns repeatedly ordered him to stop. Johns then shot some warning shots. After those shots, Palma didn't keep approaching. He was still standing there. Salvatore said Palma never got within 10 feet of Jonas. So, basically the same testimony in large. There are some differences that matter, but nothing you wouldn't expect from two people that are describing the same event, right? Two people are going to have different perspectives as to timing and things like that. So, and different recollections of exactly what said when. But you can largely view this as a consistent statement with what the officer said, but there are some troubling details, including the fact that Palma apparently, when shot at the second set of times, wasn't advancing on the officer, and also that he was down for several minutes, which would, presumably give you the ability to restrain him if that was really a concern of yours. With the statement of these various witnesses in hand, the district court now must make a decision as to whether or not to dismiss this 1983 cause of action, because this is a lawsuit. And the question is, based on all that, and especially based on the plaintiff's recitation, because that's the one we're supposed to apply, is this enough to get to a jury? So let's read on. The district court found that Johns, the police officer, acted reasonably. Johns did not violate Palma's Fourth Amendment right to be free from excessive force, and therefore Johns was entitled to qualified immunity. So the district court said this was fine, qualified immunity, so we're on appeal. Let's read some more. Johns claims the doctrine of qualified immunity shields the defendants against all the claims. The district court agreed and granted defendants' motion for summary judgment. We disagree. The record contains genuine disputes of material fact that preclude summary judgment at this stage. While the defendant bears the burden of pleading a qualified immunity defense, the ultimate burden of proof is on the plaintiff to show defendant is not entitled to qualified immunity. The Fourth Amendment prohibition against unreasonable seizures protects citizens from extensive use of force by law enforcement officers. When determining whether an officer used excessive force, courts ask whether officers' actions were objectively reasonable in light of facts and circumstances surrounding them. This test must account for the totality of circumstances surrounding the officer's use of force. The use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. And we recognize that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. When considering the totality of circumstances, the Supreme Court has articulated three factors as a starting point: the severity of the crime at issue, where the suspect poses an imminent threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. However, the Graham factors do not easily map onto cases like this one, where Johns was not responding to ongoing crime and Palma never physically resisted arrest or tried to flee. Recognizing the problem, we've articulated additional factors to consider when officers respond to medical or mental health emergencies: whether the person was experiencing a mental health or medical emergency, and whether the emergency created an immediate threat of serious harm to themselves or others, whether some degree of force was reasonably necessary to ameliorate the immediate threat, and whether the force used was more than reasonably necessary under the circumstances. Where a plaintiff claims the excessive force was used multiple times, the court must segment the incident into constituent parts and consider the officer's entitlement to qualified immunity at each step along the way. Johns argues that by tasing Palma was reasonable, because Palma was actively resisting at every turn and failing to comply with the orders to stop and show his hands. Palma never physically resisted. However, the parties agree that Palma ignored Johns' orders to stop moving and take his hands out of his pockets. Even so, this defiance alone cannot justify Johns' decision to tase Palma. If the jury accepts Johns' versions of events, that Palma aggressively approached him with a crazed look on his face, then the taser application may have been reasonable. Other evidence contradicts Johns' report that the taser was ineffective on Palma, thus undermining the reasonableness of Johns' decision to tase him multiple times. Palma fell to the ground after the second taser application. Salvarti saw Palma convulsing on the ground for minutes after Johns tased Palma a second time. Now, at this point, I might be a bit remiss if I didn't point out on a motion to dismiss standard. Of course, we take the plaintiff's claims as true. So here, it's the estate of Palma that is filing suit against the officers. So while the officer has made some interesting claims, to be sure, right, for the purposes of a motion to dismiss, we accept all the plaintiff's facts as true. So the officer has said many, many things. These things may or may not be true, in fact. But that's not the standard for a motion to dismiss. The standard for the motion to dismiss is assuming everything the plaintiff says is true. Is there enough here? And it seems like there might be, right? There are enough facts, like, for example, that he was writhing on the ground for multiple minutes, or that he didn't have a snarl face on his look, or whatever, right? So if we assume everything that Palma, via his parents, are saying is true, then it would seem that there could be some liability for the officer, which is all you're trying to decide on a motion to dismiss standard. So at this point, it's appropriate to ignore the police officer's claims because of where we are in the proceedings. When considering whether an officer reasonably believes that a person poses an imminent threat of serious bodily harm, courts must consider the totality of the circumstances. Here, certain factual considerations are particularly relevant, though none is dispositive. Why the officer was called to the scene, and whether the officer knew or reasonably knew the person that he knew was armed, which also is a bit of a question in fact. Whether the person visibly, verbally, or physically threatened the officer or disobeyed the officer, how far the officer was from the person, the duration of the encounter, whether the officer knew of any ongoing or physical health conditions that may have affected the person's response, and whether the officer could have diffused the situation with less forceful tactics. After weighing the factors, we conclude defendant cannot prevail at a summary judgment stage because a reasonable jury could find that Johns used excessive force when they first shot at Palma. When officers respond to an ongoing crime or set out to arrest a suspect, they may have some reason to fear for their safety or the safety of others based on the nature of the crime. But Johns was not responding to a past or ongoing crime. When officers are called for welfare checks or other non-criminal calls, this court looks at what the officer learned and observed about the situation before the officers even engaged with anyone on the scene. Although Johns seemingly believed he was walking into a volatile situation, indeed he had unholstered his gun before even arriving on the scene, this subjective belief was not factually supported. Johns responded to a call about an unwanted person on the property who had gotten into a fight with his sister over a TV remote. Johns was not responding to a crime. Before arriving, Johns saw Palma's driver's license and knew Palma was the unwanted person. When he arrived, Johns saw Palma standing outside the home by himself. Even if Johns believed that removing an unwanted person may involve some inherent danger, the unwanted person, Palma, was already isolated and away from the home. Thus, the facts do not support Johns' belief that he was walking into a high-risk situation. This factor therefore cuts against Johns' argument that Palma posed an imminent danger of serious physical harm. An officer need not face the business end of a gun to use deadly force. The stronger the evidence showing a person is armed, the more likely the use of lethal force is reasonable. When the evidence is weak, this factor cannot justify the use of lethal force. On the one hand, officers are often justified in shooting a person who's visibly armed and aiming at officers. However, even if a person is visibly armed, lethal force may still be unreasonable, which, would make sense because if they have it in a holster or something and are not otherwise touching it, then that might not be a basis for engagement. Although an officer may reasonably believe a person was armed, even if it turns out the person was in fact unarmed, this belief must be reasonable and based on circumstances. The fact that Johns could not see Palma's hand would not lead a reasonable officer to believe he was in imminent danger. This is the part of the opinion where I'm like, really though? I mean, really? The fact the officer could not see Palma's hands would not lead a reasonable officer to believe that he was in imminent danger? I'm not so sure about that conclusion, Court of Appeals, but okay. As we've explained in a different case called Woodcock, even if a person's hands are not visible, and even if he appears to be suspiciously reaching for something in his clothing, these facts would not lead a reasonable officer to believe the person posed an imminent threat of serious harm. Okay, I'm not 100% sure about that one. If you can't see their hands and they appear to be reaching for something, that could be viewed as a furtive movement, which could be a problem. And the fact you can't see their hands and they're in their pocket, I would think might perhaps be a basis for a reasonable officer to think that there could be some imminent danger, but the Court of Appeals say that I'm wrong and no reasonable officer could think that. When a person does not act aggressively towards an officer, that fact undermines the officer's claim that a person presented an immediate threat of serious bodily harm. Additionally, the mere factors of a citizen not arrested for any crime to follow commands does not necessarily give law enforcement authority to put the citizen in handcuffs, let alone use lethal force against him. Many undisputed facts show that Palmer was not acting aggressively towards Johns. Johns admitted Palmer wasn't walking at a fast pace when Palmer approached him. Palmer was silent throughout the entire encounter, and he never verbally threatened Johns, nor did Palmer ever make any physically threatening gestures like raising his fists. When asserting an excessive force claim, the totality of circumstances includes the fact that at the time of the struggle, the defendant officers had reason to believe that the person was mentally unstable. As Johns correctly points out, an officer is not absolutely barred from using lethal force on a mentally ill person. But only in extreme cases have we found that an officer reasonably uses lethal force against the mentally ill. In every case that Johns cites, the officers and lethal force against the mentally ill person was one against who one was armed and threatening towards the officers. Johns knew that Palma was Code 76, meaning he was mentally ill, and knew he was responding to a domestic dispute over remote control. Now, I just want to clarify really briefly that this point is in dispute, but of course, as always, we're interpreting it from the plaintiff's position. So the plaintiffs are arguing that Johns was aware from dispatch that this was Code 76, which apparently means a mentally disturbed person, so he would have been aware of that. So a reasonable officer would have taken these facts into account when assessing whether Palma posed a threat. If a person who is not suffering from mental illness acts in a way that is objectively threatening, an officer believes a person poses an imminent danger because of these actions under normal circumstances, conveys hostility. But the officer knows the person is suffering from some mental illness, the officer must consider this fact and respond accordingly. So assuming the officer was aware of this, which again is a fact that is in actual dispute, this would be something that would have to enter the calculus of the reasonableness of the use of force. As the Third Circuit has stated, depending on the severity and immediacy of the threat and any potential risk to public safety posed by an officer's delayed actions, it may be appropriate for an officer to retreat or await backup when encountering a mentally disturbed person. It may also be appropriate for an officer to attempt to de-escalate an encounter to eliminate the need for force or to reduce the need for force necessary to control the individual. While each of these factors is distinct, none can be considered standing alone. Altogether, the facts viewed in the light most favorable to the plaintiff, which again is the relevant determination here because of the stage of the proceedings we're on, so assuming everything the plaintiff is saying is basically true, this would raise a triable issue as to reasonableness of John's decision to use lethal force. Defendants focus primarily on Palm's disobedience. Palm's purported to keep walking towards Johns and refused to show his hands. But equally important is the fact that Johns knew he was mentally ill. Again, according to the plaintiffs, he knew that. The parties additionally dispute whether Johns subdued Palma after the first few gunshots. Johns claimed that Palma lunged after him after Palma had been forced into this bear crawl stance. At this point, Johns could clearly see both of Palma's hands, which, presumably doing a bear crawl, yes, but someone else disputes this event. Plaintiff's expert noted that the pattern of gunshot wounds on the bodies indicated that Palma was either on the ground, possibly in a fetal position, and/or on his knees, crawling when he was shot. These factual disputes are material because they concern the nature of any movement that Palma made before the shooting. So again, when you're looking at the reasonableness of the force, you have to break it up into different increments. And one of the increments would be after he was shot initially, forced into this bear crawl position, and the autopsy seems to indicate he didn't get back up, which is contrary to what the police officer said. And of course, the jury has to sort all that out as to what did or did not actually occur. Thus, that brings us to the end of the case of Salvatore Palma on behalf of Vincent Palma versus Matthew Jones and others. In this case, we learned that Vincent Palma was a mentally disturbed person, mentally impaired person, and that the police officer, Johns, shot him multiple times, among other violations. The question is a motion for summary judgment. The Court of Appeals notes here that there does seem to be enough evidence that if construed in favor of the plaintiff, as is the relevant standard, that it should be decided for the plaintiff. But of course, this has yet to be proven at trial. So at trial, all this evidence will have to come in, and the jury will have to determine if any of this force was unreasonable. And we'll have to go through an adjudication of those issues. So there's a lot yet to be done in this case before liability can be imparted. But at least for the moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.